Hello students and welcome to the lecture. So students, as we know that we are covering the State Human Rights Commission, right? That is the topic on which we have been discussing right now. So these are the topics that we have scheduled for the discussion under this particular series. Alright, like the beginning of human rights, like the human rights covenants, like the supplementaries of UDHR, beginning in India, chronology in India, introduction part, the composition of the commission, functions of the commission, working of the commission, human rights codes, 2019 amendment. Okay, so this is the picture that we have created so far altogether. If we talk about the topics that we have covered so far, so basically we have done with the beginning of human rights covenants, supplementaries of UDHR, beginning in India, chronology. Okay, these are the topics that we have covered. If we talk about the topics that we are left with, so we are left with the introduction part, composition of the commission, functions of the commission, working of the commission, human rights code, 2019 amendment act. Okay, so this is the picture that we have created so far altogether. So basically in this lecture we will start from where we had left in the previous one. That is the introduction part. But before this, let us remind that whatsoever we had discussed in the previous lecture. Okay, so basically in the previous lecture we had discussed that if we talk about the beginning of human rights in India, all right. So we had discussed the approach is quite different than the world. In the world where the approach was political, in India that was of the education. Okay, like we promoted the human right education so that the current generation and the upcoming generation will be well aware about the importance of the human rights. And what is the reason behind this? Because I have told you that we already had the fundamental rights and the directive principles of state policy in our constitution that promotes major portion of the components of the human rights. So that's why we didn't need a much, but we promoted it through the education. And we had discussed the formation of the commissions and the years, like the University Education Commission that was constituted in 1949, the Secondary Education Commission, okay, that was formulated between the 1952, okay. Thereafter, the Education Commission that was formulated from 1964 to 1966. Thereafter, the National Policies on Education, 1968 and 1986. Thereafter, Ramamurthy Committee, 1992. Thereafter, the Chavan Committee, 1992. They all were established, okay, to develop the concept of human rights in education as the value-oriented education system. Okay. After this, we had discussed the chronology in India, and we had found that even before the starting of the human rights, or you can say even before the starting of the concept of human rights in the world, we had the system in our country. Okay. Like in the 1829, the practice of sati was formally abolished. Like Workmen's Compensation Act, 1926, the trade unions, 1929, the Child Marriage Restraint Act, 1933, the Children Pledging of Labor Act, 1936, Payment of Wages Act, 1946, Industrial Employment Standing Orders Act, 1947, the Industrial Dispute Act, 1948, Minimum Wages Act, 1950, Caste Disabilities Removal Act, 1955, Protection of Civil Rights Act, 1956, Immoral Traffic Act, 1961, Maternity Benefit Act, 1976 Equal Remuneration Act, 1986 Environmental Protection Act, 1986 Juvenile Justice Act, 1987 the Commission of Sati Prevention Act, 1990 National Commission for Women Act, 1993 the establishments of Human Rights Commission by themselves, 2005 Right to Information Act passed, and even in the 2010 the Right of Children to Free and Compulsory Education Act came into the force. Okay, but here in the end you will find that this is etc. It means that all of these things are not limited here, but even they are widespread form. Okay, so now let's start the formal introduction of the Human Rights Commission in India. Okay, and you can see the State Human Rights Commission, because about the Human Rights Commission at the national level, that is known as the National Human Rights Commission or NHRC, we had already discussed in our NHRC lecture. Okay, so basically if we talk about this, so the Protection of Human Rights Act 1993, remember that is the particular act. So here what you have seen here, let me conclude it for you. Like if we talk about the beginning of the human rights in the world, all right, so we know even before the world we had the concept in our country, like starting from 1829, all right, the beginning of the passing of acts began already on that time. Okay, thereafter we know after the World War era, all right, and you can say during the colonial eras, basically the entire world felt that there should be a system of you can say fundamental international rights that are given to every individual irrespective of the nationality, irrespective of the gender, irrespective of the racial discrimination. All right, and then we know there was a first commission appointed by the United Nations under the chairmanship of whom? Who was the chairman of the first Human Rights Commission? Now it is a question to you, and to answer this question, you have 30 seconds. Okay, so your time starts now. Just think about it. I had repeated the name in all the past 3 lectures, so I hope that you will recall it quickly. 10 seconds have been passed off, last 20 are remaining. Just think about it. Last 10 seconds. Alright. So the person name was Eleanor Roosevelt. Eleanor Roosevelt was the first person who was the head, you can say, who was the head of first Human Rights Commission constituted under the United Nations. Okay, we know this. And we know basically the commission had formulated the UDHR on 10 December 1948, and then 10 December is known as the Human Rights Day. After this, in the 1948, during the 1973, the 2 new convents discovered, like the ICCPR, okay, stands for the International Covenant on Civil and Political Rights. Second one was ICS ECR, that is International Covenant on Social, Economic and Cultural Rights. And they 3 combined together and formed the International Bills on Human Rights. Even after this, when we were talking about the supplementaries of UDHR, like I have told you, there is a same concept that we used to follow in our school colleges. Okay, like there is a course book, and it is not necessary that each and every topic is detailed explained in the course books. So that's why we usually have the supplementary books as well. Got it? So there were supplementaries to the human rights also, and these supplementaries are 20 principal treaties. Okay, so now you can see that basically the development of the human rights at international level began in 1948, then carried on in 1973. Even after this, the region like the Eastern Europe, Africa, Latin America and all, they even modified the concept as per the regional demands, and you can say as per the regional needs. But when we talk about India, so basically during the 1948 or 1949, India also started appointing the human rights commissions, but not in the form as they got appointed throughout the world. Okay, so basically, India usually appointed the Education Commission, and the Education Commission with themselves had the task to prepare a default for the human rights. Got it? But even after there was no formal human rights commission established in India. Okay, and you can say there was no dedicated organization that could look after the human rights condition in India. All right, so that's why that is the, you can say, one need. Okay, like there was no dedicated organization looking after the human rights. That is only the one need. Apart from this, there was also the one reason. And what was that? Like I have told you many times, the normal people get confused between the human rights and the fundamental rights. Okay, and they often consider the human right as equal to the fundamental rights. That is the half truth, as we had discussed in the beginning of the series. Why? Because the human right is much more broader concept than the fundamental rights. And even you can say the fundamental rights are the part of the human rights. Okay? And if we try to compare it, so we can say, like if we take the case of ICCPR, okay, International Covenants on Civil and Political Rights. So which rights they were covering? Like right to speech, okay, right to life, voting rights and all. Okay. So here you can say that these rights are very much similar to the rights that we have provided under the heading of fundamental rights. Okay. So here you can say the fundamental rights by themselves are the part of the human rights. But entire human rights are not the fundamental rights. Got it? That is the thing. So basically, the Indian judicial system that is usually, you can say, responsible for ensuring the protection of the rights of the individuals, whether in the fundamental sense and all. And even we can say, if we look after the fundamental rights are more oriented towards the political freedom. Okay, they were not so much inclined towards the human rights and all. Okay, but they mainly emphasized on giving the political freedom that we had already discussed when we were discussing the fundamental rights. Okay, like if we talk about the Indian Constitution promotes the democracy and promotes the democracy in the three forms: the political democracy, the social democracy, and thus the economic democracy. There is a three kind of democracy in our country, that all we had discussed. And then we had discussed that there are two main provisions provided in the Constitution that promotes this democracy. Like the fundamental rights promotes the political democracy, okay, and the socio and economic democracy promoted by directive principles of state policy, DPS in short. Okay, but the human rights are much more higher concept than the political democracy. Okay, so now take back to the judiciary. So the judicial system, if we talk about it, so we know the judicial system is limited. Okay, their application, their apply form is limited. However, in India, we tried a lot so that the judiciary could be available for each and every individual who is living in the country. But due to various issues, if we compare the provision on paper with the provision on grounds, then we know there are many things on paper, but there are less things on ground due to various reasons. Okay, so that's why the judiciary was already under a lot of pressure, and the judiciary was not effectively working for the dedicated human rights organization. Okay, so even you can say, if we talk about the cases of fundamental rights, the fundamental right having the Article 32, which is the fundamental right itself. Like if someone's fundamental rights affects, then the person could directly move to the High Court and the Supreme Court respectively, okay, under the Article 32 and Article 226. But what if the human right of someone get hurt where it should move? He could move to the ordinary courts like district, Supreme and High Court. But there will be a time, even when the courts are already under the pressure. So that's why there was a condition that a dedicated organization which will look after the Human Rights Commission that was missing in our country. Okay, so to check out this, basically that was the tenure of 1993. Now you can compare it. Like the first dedicated provision on the human rights was came in 1948, or you can say to be more specific on 10 December 1948. Okay, even the system was modified in 1973 with the International Covenant on Civil and Political Rights and International Covenant on Social, Economic and Cultural Rights, and that forms the International Bills of Human Rights. But in India, that was firmly conferred in the 1993. Okay, so the 1993 was the year in which India looked after establishing the permanent, dedicated organization that will look after the human rights in an effective and efficient manner. Okay, and for this, we know there is a dedicated act that we had passed during that time, and this is the Protection of Human Rights Act of 1993. Protection of Human Rights Act of 1993. That was the act that provides for the creation not only the National Human Rights Commission that will look after the human rights violations throughout the country, but also promoted the State Human Rights Commission at state level. Why? Because if we look at the country in which we are living right now, so what is the condition with the country? India is a vast country with a huge population, and you can say with the world's most dynamic population that we have in our country. Okay, so that's why it is not possible for the National Human Rights Commission that they will look after each and every human rights violation in the effective and efficient manner. That's why at the state level, or you can say at the territorial divisional levels, basically we had started the State Human Rights Commission. So here we can say the Protection of Human Rights Act of 1993 basically is the common act for the establishment of both National Human Rights Commission and the State Human Rights Commission, and they both were created at the same time. Okay, there is no separate act for the National Human Rights Commission and the State Human Rights Commission. Okay, and thus we can say accordingly 26 states have constituted the State Human Rights Commission through the official commission or official gazette notification. How many states? 26 states basically constituted the State Human Rights Commission. Now here most of you will conclude that in India there are 28 states. Okay, then 26 states only. So what were those two states which did? So let me tell you one thing very straightforward. If we look after the evolution of the state in India, okay, then it is not the same. Why? Because we know when the Britishers left India, then India was divided into the two categories: the British India and the princely states. Over the period of time, various states get merged together, various states were detached from another state, and that's how the landscape that today we see, that landscape was formed. Alright. Even some of the states were created after the year of 2000. Okay. So when we were talking about 1993, it means that on that time the states were not as much as they are right now. Okay. So just keep this thing in your mind. That's all I have told you right now so far. Okay. So if we talk about the State Human Rights Commission and its power, so remember, the State Human Rights Commission can inquire into the violation of human rights only in respect of the subjects, in respects of the subject that are mentioned in the state list and the concurrent list of the 7th schedule of the Constitution. Like whenever we talk about the legislative power division, okay, between the governments. So we know in India there is a you can say division of the powers in the government. Like there are the two governments, the federal structure is there. The central government, oftenly regarded as the union government, the state government, oftenly regarded as the provincial government. And in the same year of 1993, we passed the 73rd Amendment Act and 74th Amendment Act that created the third form of the government that is called local government. Okay, but if we talk about it, federal structure as per the Constitution, then the Constitution had provided for the two divisions. the central government and the state government. And as per the division, even their legislative powers got divided. Okay, like there are three, you can say, list in the constitution. The union list is the list on which the central governments can make rules and regulations. The state list is the list in which the state governments will make rules and regulations. Concurrent list is the list which contains the topic on which both the central and the state government in the considerations can make the laws. So when we talk about the State Human Rights Commission, so they could take up the violation of human rights only in respect of the subjects that are mentioned in the state list or in the concurrent list. And these lists are basically provided under the 7th schedule of the Constitution. Got it? However, if any such case is already being inquired into by the NHRC, or you can say National Human Rights Commission, or any other statutory commission, then the State Human Rights Commission does not inquire in that case. What we have seen here, we have seen that, however, as per the Act of Protection of Human Rights 1993, as per the Act, basically the State Human Rights Commission got a power that they could inquire the cases of human rights violation respect of the subjects that are mentioned under the list 2 and the concurrent list. But there is an exception also. If any of the matter that are considered under the list 2 and the list 3, but that matter is already under the inquiry or the consideration by the National Human Rights Commission or any statutory commission. So, on that time, the State Human Rights Commission will not inquire that matter, even if the matter falls under the list 2 and list 3. Okay, remember this thing. After this, we can say the central government may confer upon the State Human Rights Commission the functions relating to the human rights being discharged by the union territories except the union territory of Delhi. What does it mean? So basically, if we talk about it, then we can say the central government having the power, like they can ask the State Human Rights Commission, and you can say even they can grant a permission and power to the State Human Rights Commission that they could check out the human rights violations under the union territories. So we know in India there is a 3 territorial divisions, or you can say there are 4 basically: central, states, UTs, and the territories administration that may be acquired by India at any time. Got it? So basically, if we talk about the state and the UTs, okay. So, however, we have the different lecture on this, so I'm not going to tell you much more about it right now because we will discuss this in detail in the next lecture, or you can take the lecture of the union territories. Till then, just remember, basically the union territories is the territorial division that comes under the central government. Okay, doesn't matter even it falls under the territorial limits of some government, or you can say or the state government, but still the central government having the right to govern the union territories. Alright, so if the central government wants that a particular State Human Rights Commission to which the particular UT is attached or lies within the state, so central government may confer the power that that particular state's Human Rights Commission could look after the cases. Okay, but this provision is not applicable to the Union Territory of Delhi. Okay, why? Now here please do not get confused between the Delhi and the New Delhi. Okay, Delhi is the Union Territory while the New Delhi is the capital. Alright. The functions relating to the human rights in case of Union Territory of Delhi are to be dealt with the National Human Rights Commission. Okay, it means that if there is any human rights violation, and you can say if there is any case of human rights violation that is reported within the Union Territory of Delhi, so that will be looked after and that will be dealt by National Human Rights Commission. National Human Rights Commission will look after that case. Alright. So students, basically this lecture, you can say that we have finished till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.